Ms. Lean.
My Lords, there's just one point I want to go back on, I'm afraid, from yesterday. It's very hard as an advocate to resist the temptation, but I hope that it will assist with why we say that what happens in this case are configuration changes. So I'm going back to the adapted to point. And there is some evidence, which I didn't show, my Lords, yesterday, but I think does have some, or cast some light on this point. First of all, there's the evidence of Mr. Rousel, and that's in supplemental bundle at tab 19. And this was unchallenged evidence. And if my Lord could go to tab 19, page 280. So Mr. Rousel was a witness of fact, and as explained at paragraph 7 on 280, he was instructed by Apple solicitors to plan and conduct testing in order to determine the values of a number of different parameters. And then, as the statement goes on to explain, the parameter NCS had the field name NCS AN, and he explains at paragraph 8 when the base station cell may signal the value, and he says at paragraph 9 that he proposed measuring the value of NCS and signal periodically, because that could be done in a relatively straightforward...
Miss Lane, I'm sorry to interrupt you.
Yes.
I'm sure it doesn't matter.
Yes.
But can you just briefly explain to me why it is that what is obviously an experiment is before the court in the form of a witness statement from a witness of fact?
My Lord, that wasn't a point that was taken by Optis, and as I recall, although I don't have all the facts at my fingertips, what happened was a notice to admit was served, and that a non-admission wasn't initially forthcoming, and so then this evidence was served.
Yeah, so that's the same procedure for a notice of experiments. You ask them to admit it first. If they don't admit it, you serve a notice of experiments. I mean, it is plainly an experiment, isn't it?
Well, my Lord, certainly it could be argued that it was an experiment.
It's
it wasn't
testing.
Argued,
He says it's testing.
But my Lord, this is uncontested evidence.
To be sure, but yeah, we have these procedures for reason. Of course, it turns out in this case that nothing, it doesn't matter. But
yes.
Nevertheless, for future reference, this is an experiment.
Yes, my Lord, I'll bear that in mind for the future. So paragraph 10 is the paragraph I wanted particularly to point out, which was the first sentence. The SIB2 messages include the information element push config common, config obviously being a short for configuration, which it then explains is used to communicate configuration information for the LTE physical uplink control channel push, including the value of NCS AN. So the point there, of course, is that the term configuration information is used there, and as we know, configuration is the wording in the case IP common Vodafone that we've been looking at. And there's a little more background which in my submission is useful as well in the evidence of our expert, which can be found in, if one goes back to tab 9, page 205.
Sorry, just before you
Yes.
go on, what exactly do you say the configuration information that is being referred to in the first sentence of paragraph 10 is?
Well, one of the things it is this value of NCS AN.
Right.
As I understand it, reading para 7, Ms. Lane, NCS AN is the RRC layer name for the parameter NCS.
Yes, exactly. And so the configuration information includes the value of NCS AN. In other words, it includes the value of NCS1.
Right, and how do we know what Mr. Rousel means when he uses the expression configuration information?
Well, my lord, he wasn't cross-examined, so this is to be taken at face value. And the basic point this is making is that this is being referred to as configuration information, and that wasn't something that was challenged. And I say that's the point that helps me, because obviously it demonstrates that that's terminology that is used by Mr. Rousel, and as we'll come on and see, it's also used by Mr. Edwards, who was our expert.
All right.
So that's back in tab 9 at page 205. And there's heading use of the mixed resource block in the UK about halfway down page 205. Then there's a reference to Mr. Rousel's evidence. And then at paragraph 397, Mr. Edwards says, I do not have personal knowledge of the particular putsch configurations used by any UK network, including as regards the value of NCSAN. So again, NCSAN or NCS1 is being referred to as part of the putsch configurations, and he couldn't do the testing himself. However, he provides some context, he says, which may explain the results of the testing, and that context is provided from paragraph 398 to 403. Could I just ask my lords to read those paragraphs, please?
So, the context for all of this is 396. He's been asked to comment, based on his expertise, on whether the mixed resource block has been used, or is likely to be used in the UK.
Yes.
The answer he gives is in the negative, and that's not in dispute.
Indeed.
So he's answering a completely different question.
Well, a completely different question from what, my lord? Sorry.
To the question of that we are concerned with respect to adapted to.
Yes, absolutely, my lord. I accept that, but I wanted to point out two things. One, the fact that both these witnesses use the term configuration, and I say that's helpful.
So what does that mean? Well, how on earth does that help?
Well, my lord,
this is pure semantics.
Well, my lord, it's not unhelpful when we're trying to decide the question, or looking at that question, of whether or not there is a configuration change. The fact that in undisputed evidence, it's referred to as a configuration. So that's one point. But the other point that I wanted to look at was the question of what exactly has to happen in order for there to be a mixed resource block. And in particular, my lords will have seen at paragraph 400 that the witness explains, or the expert explains, that for narrower bandwidths, there may be circumstances where the flexibility provided by the mixed resource block minimises the number of resource blocks required for signalling, and so increases the system's efficiency. However, for the higher bandwidths, that's 5 megahertz and above, it's unlikely to be optimal to use a mixed resource block. And that's why mixed resource blocks are not deployed in the United Kingdom. And in order to be deployed in the United Kingdom, as he explains at paragraph 402, you would have to have either UK networks being provided with different and lower allocations than 5 megahertz, megahertz, or operators would have to break down their spectrum to use lower
But
bandwidths.
what does this add to the uncontested fact that this isn't implemented in the UK?
Well, in my submission, it adds this point, which is my Lord mentioned yesterday that a possible difference that might be said to occur with between this case and IPCOM and Vodafone is that in IPCOM and Vodafone there had to be some kind of human decision making before the particular setting change was carried out. And in my submission, exactly the same can be said in this case, in that it's not simply a matter of changing the numbers, because someone has to make a decision to do that, because they won't be doing it unless.
So you're talking about a decision as to whether to implement lower frequency bandwidths, or sorry, narrow bandwidths down at 1.4 megahertz, for example. I mean, that's a major system-wide decision. It's not specific to the question of what CMS you're using.
Well, there's a chain of events. So the first event is you get the spectrum allocation. And if the spectrum allocation is as it is in the UK currently, then it doesn't provide for allocations lower than 5 megahertz. So no one is going to want to use mixed resource blocks unless operators decide to break the spectrum down into lower bandwidths. Now, at that point, they may then take the decision to use mixed resource blocks. They're not going to do it otherwise. Having taken the decision to use the mixed resource blocks, they've then got to signal the parameters. And so what I'm pointing out is, obviously, one can look at this as a whole chain of events, starting off with a human decision to allocate a narrow spectrum, ending up with the transmission of the configuration information. And that, I would say, is equivalent to what is set out in steps 1 to 7 in paragraph 107 of IPCOM and Vodafone. Alternatively, one can simply focus on the transmission of the signal, i.e. the fact that certain parameter numbers are signalled in order to have a mixed resource block with the 2 cyclic shift interval. And that particular step is equivalent in my submission to step 5. And so obviously the reason I'm raising this point is because my Lord mentioned yesterday the fact that human decision making was involved in, or could be said to be a feature in IPCOM and Vodafone. And I say, if we look at that same level of generality at the whole steps 1 to 7 in IP and Vodafone, and then we consider the similar type of steps that would be taken in this case, then there would also be human decision making. But my primary submission is that we just look at step 5, we look at the signalling of the parameters, and that is good enough because those, not among other things, those are actually called configuration. That's actually called configuration information, and so we say, well, that therefore falls within configuration. So, unless my lords have any further questions on that, I was planning to now go back to the COBE agreement and the judgment on the COBE agreement. So, back in the judgment, and I'm just going to start a little bit earlier because there was a paragraph that I didn't show my lords yesterday, which is paragraph 50 on page 78. And this is coming back to the point I think my Lord Justice Arnold asked me about, was this all about CGK or was it about construction or interpretation of the COBE agreement? And I just want to show my Lords for completeness, paragraph 50, which is on core page 78, where he's introducing CGK and the sources of CGK. And the judge states, I do not rule out that a significant firm decision at a round 1 meeting could be CGK. The COBE agreement may be an example. And he says he's going to addresses it in detail below. And that's really just the first place where in my submission what the judge does is equate CGK with the COBE agreement. which is why we say that you can just look at what the COBE agreement means, but he does it in other places. So he also does it at paragraph 177, which is on page 99. At the bottom of that page, consistently with my views as to the skilled person who approached the CGK in this case, the fact that the decision is recorded in meeting minutes would not, without more, make the COBE agreement CGK. So again, I say he's equating them, and likewise in paragraph 178, the CGK would include the COBE agreement, which is why what then happens, and what we say is the question is, how do you construe the COBE agreement? And he addresses that starting in paragraph 179, where he says that he doesn't think that the COBE agreement is ambiguous, and he refers to the fact that it was the index of control channel, and then expanding on that, it might have been possible for it simply to have been in favour of implicit signalling, or it might have been the delegates decided for a specific kind of implicit signalling. And obviously I've already explained why, the reasons why we say that is wrong. Yesterday I think I went to various evidence references. We say that it doesn't make sense because the UE doesn't know what the index of the control channels is, that the evidence of Optis's own expert, Mr. Bradford, was that the COBE agreement was unclear, and the Panasonic document that we went to yesterday says it's capable of two interpretations. And so our primary position, as I've already mentioned yesterday, is that we say that you don't need to go to document R1072472, and that is consistent with the judge's finding.
You went further. You said not merely that it wasn't necessary, you said it was precluded.
Well, yes, I say that's what the judge's judgment says, that the skilled person would be unlikely, I do not think the skilled person would be likely to go back through proposals leading to the COBE agreement. So I say that's the decision of the judge, that's not being challenged, and therefore on appeal that stands, and one doesn't go to that document. However, I do want...
Yeah, but we're still left with the problem that the judge seems to rely upon it, 472, because he says it's consistent with, in a broad sense, supports his reading of the document.
Well, my lord, let's go to that document, because in my submission it doesn't take matters any further or help one way or the other. And that document is at supplemental bundle tab 17. And you can see that it's a summary of email discussion on uplink control signalling, that's the title. Then you've got a section introduction, and just above the bullet points it says list of discussion topics. And the only one of these discussion topics that's relevant is the third bullet point. That's how to associate the uplink ACNAC resource with the downlink scheduling decision. Two main approaches have been mentioned: association with the control channel index, and then it says it won't work in certain circumstances, and then association with downlink resource blocks. Now, obviously, association with the control channel index is the one that is relevant, but nothing more is said about how that is going to be done, and so it doesn't add anything, in the sense it doesn't tell you what to do about the fact that the UE doesn't know what the index of the control channels is, which obviously is the same problem with the COBE agreement. And then if one turns over the page, there's a bit more text about this at the bottom of 274, at paragraph 2.3, association of ACNAC resources to downlink transmission. Says the views of different companies are summarised below. For non-persistent scheduling, all companies stating a view propose to link the ACNAC resource to the index of the control channel used for scheduling.
So why does this document not support the judge's interpretation?
Because the judge's interpretation is essentially, it says control channel index, and that's what it means, end of. And
what's wrong with that?
well, what is wrong with that is that it doesn't make technical sense because the UE doesn't know what the index of the control channels is. And so since the whole purpose of this is to be using implicit signalling, i.e. something that the UE already knows, then it's not going to work unless you have some extra explicit signalling on top, which is the problem that the Panasonic document points out.
You seem, maybe I'm missing the point here, and that's entirely possible. But you seem to be making a different point to the one that I was putting to you. What I was wondering about was whether it was not the case that 472, and in particular the two passages you take us to, supports the judge's interpretation of the Kobe Agreement as a document, to which your response is, but it doesn't make technical sense. But at the moment, that seems to me to be a different point, because that's saying, yes, the Kobe Agreement means what the judge said it meant, but his interpretation doesn't make technical sense. And that I think, is a different question, isn't it? Because it's perfectly possible for a document to say unambiguously, we propose you do X, and for the skilled reader to know, actually, that makes no sense.
Well,
They're different questions, aren't they?
If it doesn't make technical sense, then that's a reason why it's ambiguous. Because the
No, it's a reason why it's wrong. It's not ambiguity.
Well, the problem, of course, is that the three different options are control channel index, control channel element index, and control channel candidate number. And so one can see that control channel index might simply be a shortening of one of the other two, which is why when you
Pretty unlikely when you look at 2.3 in 472, where it is talking specifically about the index of the control channel.
Well, there are different circumstances, aren't there, Miss Lane? You can have a situation in which a document says the moon is made of green cheese. That's what it says.
Yes.
And it definitely says that. It means that. Everyone would understand what it meant, and everyone would think it was nonsense. That's one possibility. Another possibility is it says something which, again, is pretty clear, and I can't think of an example, but it doesn't matter, where potential ambiguity of it, or the sort of potential nonsensicalness of it, might cause someone to say, well, is that what it really means, or does it mean something more sensible? That's possible. I can't think of an example, but I'm sure masked brains in this room will think of an example very soon. But that's a possibility. As you say, you read it and you say, well, at face value, the literal language seems to be saying something silly, but there is actually a more rational interpretation, which may not be quite what the literal words appear to say, but if I think about it, I understand that that's what it really means, and that's what it means, and that's possible too. Or there's something which is actually clear that it means something else. They're all possible. So I'm not entirely with my lord in saying that the fact that it might be silly, might be a silly solution, is always and necessarily irrelevant to its construction, but it can be. It just depends, doesn't it? Why are you on the ambiguity is relevant to construction side of the line, no, stupidity is relevant to the construction rather than it just means something silly side of the line? How do we decide which side of the line it is?
Well, you've got the Panasonic document that says it's capable of two possible interpretations, and you've also got the evidence of Mr. Bradford, Optis's expert, that it was unclear. Mm-hmm. So both of those things help you decide that in fact it's ambiguous, rather than.
Why was the judge wrong to say that it's not ambiguous? It may be mistaken, but it's not ambiguous. What's wrong with that as a conclusion?
Well, we say it is not consistent with these other points that I'm explaining. Panasonic doesn't make technical sense. Mr. Bradford himself said it was unclear. So, just looking at how the judge dealt with Panasonic, because this was also part of his reasoning, and that comes at paragraph 182 of the judgment. He says subsequently there was further discussion about the Kobe agreement, and in particular that it was open to two interpretations. And he talks about the fact that Panasonic suggested there were pros and cons, in particular that the former would use more overhead than the latter. And we say that doesn't really grapple with the fact that it's not just that it would use more overhead, but because, as Panasonic explains, it would require the same amount of overhead as explicit signalling. And so it sort of defeats the object of having implicit signalling. We did look at Panasonic yesterday, but we can go back to it if that would help. The second point...
Do you challenge the judge's conclusion that Panasonic is not CGK?
No, I don't, no.
You don't challenge that?
No. But it does tell you, it's an example of a contemporaneous document that demonstrates how people read the Kobe agreement as having two possible interpretations. I mean, that's exactly what Panasonic says. It says it's got two possible interpretations, and that is completely consistent with Mr. Bradford's expert evidence that it wasn't clear.
Just to be clear, Ms. Lane, I don't want you to under a misapprehension. It seems to me that I understand the point you've made, but if the document isn't common general knowledge, then the fact that the control overhead may be the same isn't something that's relevant to the construction of the Kobe agreement.
Well, my lord, the Panasonic document itself isn't CGK, but it effectively explains Mr. Bradford's evidence about why it's unclear. I mean, it's just supportive of Optis's own experts' evidence that the Kobe agreement wasn't clear, and we went to those passages yesterday.
I mean, it may be that the point was put, but I think, doesn't the question come then to this, that are you saying Mr. Bradford accepted the technical considerations that underlie the Panasonic document?
I can't actually remember that off the top of my head, but I can check that point. I will ask my junior to look at that.
Because if he accepted the technical considerations underlying, then you have an important point in your favour. And it's got nothing to do with the Panasonic document itself.
No, but I mean the Panasonic document, as I say, just is supportive of the position that people in the field at the time thought it was ambiguous.
Because if you have an expert who accepts the technical considerations, then you're in a strong position. Otherwise, why is the judge not right to simply take the view, here is a document which is accepted not to be common general knowledge, and it's argumentative? The real question is, are the technical considerations right or wrong?
Yes, my lord. I'm just quickly reminding myself of bits of Mr. Bradford's evidence. My lords, perhaps I should continue and I can get my junior to look it up, otherwise we could be here some time and I've already taken up quite a lot of my lord's time, but my junior can check those references. Moving on to the judge's other reason in paragraph 182, which was his finding that the Panasonic document was a diplomatically phrased attempt to reopen the Kobe agreement. We say that there's simply no evidential basis for that, and indeed in reality, the evidence, as I've already said, was that of Mr. Bradford, that the Kobe agreement wasn't clear. So that is not consistent with the finding that it's a diplomatically phrased attempt to reopen a clear agreement. The evidence was it wasn't clear. And so we say that that finding wasn't open to the judge.
So what evidence would a judge need? I mean, that doesn't look to me like the sort of conclusion a judge needs some evidence to have an evidential basis when trying to assess whether a document is clear or not, and whether another document which talks about it it seems like a legitimate thing for a judge to do. Doesn't need an expert or a witness to say, I think this is a diplomatically phrased attempt to reopen the other document. Is that your submission, that the judge would have required evidence that said that in order to reach that conclusion?
Well, yes, in the circumstances of knowing what the document says, because the document says it's capable of two interpretations. So that suggests that the Kobe agreement is not clear, not that someone is trying to reopen it. Because
what if the judge is right the first time around? So suppose you have one document which is clearly saying X, and you have a subsequent document that says, well, it's X or Y. Why is it not open to a judge to say that some document is plainly attempt to re-argue what was in the first document?
Because the document is not saying the original document said X, but actually we think that that was the wrong decision and it should have said Y. It says the original document wasn't clear as to whether it was X or Y. I mean, that's what it says. And then we think that, well, then it sets out the pros and cons of those two interpretations.
You're presupposing that in fact the first document is unclear. Because if the first document is clear, then the judge's conclusion follows quite reasonably, doesn't it?
Well, my lord, it's all to do, as I say, with how the Panasonic document is phrased. And it's not suggesting that what's happening is that they think that the wrong conclusion has been reached in the Kobe agreement. It's just saying it's capable of two interpretations, let's sort this out. And as I say, and I know I keep going on about this, that's consistent with Optis's own experts' evidence. So it's not a crazy point, it's what Optis's own experts said. This agreement is not clear.
Slane, I'm sorry, I'm not going to let this go.
Right.
Your submission is that there is something that has no evidential basis.
Yes.
And I want to understand that submission, because if it's a good point, it's an important point.
Yes.
And I don't understand why there needs to be an evidential basis. That was what you said.
Yes.
For this conclusion. Now, as I understand it, you would accept. Well, I don't know. I shouldn't put words into your mouth because I'm not sure that's right. When pressed on it, what you say is that it's wrong. Now, that's different from having no evidential basis. And I'm trying to understand on what footing you say that there was a requirement for an evidential basis for this conclusion.
Well, perhaps.
I mean, it's a phrase that counsel used quite a lot, and I'm wanting to make sure that I've understood what the dare I say it, basis for that submission is.
Let me put it like this, my lord, and I hope that this answers the question. The first point is, as a matter of fact, there is no evidence in the case that says what was going on in Panasonic was that people didn't like the decision made in Kobe and were trying to reopen it. So there's no evidence to say that's what was happening.
Okay.
So in that sense, there is no evidence that supports what the judge says here.
Equally, no evidence to contradict it.
Equally, no evidence
well, in terms of fact evidence, as I understand it, there's a vacuum.
Yes.
We just have the document.
And so then we come to the question of, well, what evidence is there? There is the evidence of Mr. Bradford that the Kobe agreement was not clear. And we say, well, that is inconsistent with this finding, because this finding assumes that it was clear but had to be reopened.
But isn't there a much simpler submission that's open to you, which is to say what the judge doesn't do here is to refer to the evidence of Mr. Bradford. He had expert evidence that the document was ambiguous when viewed through the eyes of the skilled person, and that expert evidence was also incidentally supported by the contemporaneous document in the form of Panasonic.
Well, my lord puts it more attractively than I did, but I hope that I was making those 2 points. It was perhaps I was making them the other way round, but I like the way my lord made it, and so I'll adopt that. Right. So, subject to my junior checking whether Mr. Bradford specifically addressed the technical points, which I think we'll need to come back to perhaps at the end of my submissions. I'm now going to just quickly talk about some of the points that Optis raises in its skeleton argument on the Kobe agreement. And these are as follows. First of all, they say, well, it was technically possible to index the control channel. And I think the reason for saying that is they say, therefore, that our submission that it didn't make sense to do it that way doesn't hold. And we say, well, no, yes, it was technically possible to index the control channel. We all agree with that, but that doesn't detract from the point that it wasn't clear how that would be done, and indeed doesn't detract from the point that you've got to have additional explicit signalling, which is not what you want when you're talking about implicit signalling.
So explain, these submissions that you're making now are on what topic? On the ambiguity of the Kobe
Yes,
agreement?
I'm still on the Kobe agreements, and I'm just trying to pick off some points in Optis' skeleton.
Okay, thank you.
Then they say Panasonic was not CGK, and as I've already indicated, we accept that, and we just simply rely on it to reinforce our points that the agreement wasn't clear, and that using the control channel index had the technical problem of more overhead. They then rely on various documents predating Kobe, which they say suggest the control channel index. And we say, well, the judge has said certainly that paragraph 181, that you wouldn't go back through the proposals leading to the Kobe agreement. So he's more generally saying, in addition to saying you wouldn't look at 472, he's saying you wouldn't look at just the proposals leading to it. And I mean, they're not even mentioned in the minutes themselves. And then it's submitted that Panasonic suggests amending the Kobe agreement, and we say no, it says 2 interpretations, and it talks about clarifying it, and we've already gone through the fact that it's supported by Mr. Bradford's evidence. And then there is a reference to another document, which is another email from Mr. Parkval, post-dating the Kobe agreement, and I'd like to turn that up, and that's at supplemental bundle tab 24. Page 309 is the bottom of the email chain. And so this is some email correspondence from Mr. Parkval with other people about various discussion points. And in the bottom email on 308, he says it's time to restart the email discussion on uplink control signalling. Below is a list of open issues, which I hope we can progress until the Shanghai meeting in October. And then he lists various things, and the final point is point 6. Which resource, etc. How will the UE know upon which resource to send the ACNAC implicitly from the RBs used, from the first CC used, or explicitly in the downlink grant? Explicit signalling will incur an undesirable increase in control signalling overhead, etc. And then there's a response from Juho Lee, which is on the next on page 308, the previous page, and he says, before getting into real discussions, I would like to clarify that we already made a conclusion on the putsch resource as follows, and then sets out the Kobe agreement. And then Mr. Parkwell says there are still a few details to sort out, though. For example, as the CCEs can be aggregated in different ways, it may be hard to number the control channels, and linking to the index of the first CCE in the decoded control channel is an alternative. And we just say, well, that email chain as a whole is equivocal, and if anything, it supports our contention that the control channel index was not, or the Kobe agreement was not viewed as being clear, and the control channel index had problems associated with it. So we say that that just doesn't take the matter any further.
I'm not sure I quite understand the point you're making. Is this still on ambiguity? Because if it is, I'm not sure why you say this supports ambiguity, given that Mr. Parkwell's email of the 5th of September clearly presents the first CCE in the decoded control channel as, to use his words, an alternative, i.e. an alternative to what was in the Kobe agreement.
Well, my lord, what it's saying is it's not clear that the control channel index is something that is going to work. So it's supporting the point that there are technical problems with it.
But again, that's a different point to ambiguity. That's saying it's tolerably clear what it means, but it's not very satisfactory.
Well, as I said previously, I've got these 2 points on ambiguity. One is it doesn't make sense technically, and that's why it's ambiguous. And the second is the expert said it was ambiguous. So it supports the first of those 2 points. I mean, in any event, as my lords will appreciate, we say that you don't go to this email. So, my lords, that was all I was going to say for the moment on the Kobe agreement. And I was going to come to the construction of the claims of the 810 patent now. So, the best place to start is in the judgment at paragraph 203. And that's on page 105 of the core bundle. And what we have here at the bottom of page 105 is paragraph 203, claim 1 of 810 is as follows, and the judge explains that the additional issue raised by it depends on integers 1b and the opening part of integer 1l. And so we can then see those in the following pages. 1b talks about a receiver configured to receive control information on a control channel element, CCE.
I beg your pardon, it's entirely my fault. When we were looking at the claims yesterday, I pulled the pages out of the bundle and then put them back in the wrong place.
Yes. Well, I'm afraid I induced my lord to act in that way.
No, it's my fault for being cack-handed when I put them back. So could you just give me the reference again?
Yes, sorry, it's page 105 of the core bundle. It's right at the bottom, paragraph 203.
Yeah, thank you.
And that's, the judge explains, this point depends on integers 1b and the opening part of integer 1l. It's actually really about the opening part of integer 1l, but 1b is sort of introductory, a receiver configured to receive control information on a control channel element. And then at the opening part of 1l it says the CCE is associated with a physical uplink control channel, and the putsch is determinative of a cyclic shift value among blah blah blah. And so the bit, just so we all know, that we care about is the CCE is associated with a putsch, and so that's the question we've got to decide. What does that mean? And there is a minimal level of agreement in that the parties agree that this describes implicit signalling of some sort. And Optis said that it meant that the CCE index or CCE number must be used. Apple said that the claim covered both that and use of the index of the control channel. So Optis says it just covers CCE numbers, or the otherwise known as the index of the CCEs. And we say, yes, it does cover that, but it also covers the index of the control channel, which obviously is the thing that the judge found the Kobe agreement means. So we're going to need to look...
You've gone to great lengths to tell us wouldn't work.
Well, I said that it's got technical problems, yes.
Right. Yeah. Okay. I just understand the beginning of 1L. It says CCE is associated with a physical uplink control channel PUCCH. And then it says, and the PUCCH is determinative of cyclic shift. So is what this is really saying, this reference to the punch, sort of, I'm sure it's very important, but really what's going on, at least in my mind, is that it's the CCE which is associated with the cyclic shift value. You do it by means of, as it were, going through conceptually the channel, because really what channel is, in the context of these patterns we've been looking at, is the rectangle
Yes.
we're interested in. And
Yes.
conceptually that rectangle is effectively the same thing as a channel from
Yes.
the point of view of the communication between the phone and the base station.
Yes.
It's not always as obvious as that. Okay, thank you.
And we say that on the language, just first of all, of the claims, before we turn to the description, that the language is wide enough to cover implicit signalling being via the index of the control channel. And the reasons for that are that the control channel is itself made up of CCEs, and that is not in dispute. If one turns back to 173, for example, you can see described in that paragraph that there would be CCEs in the. Actually, that's not a very good reference, but certainly when we come to the patent, we'll see that the control channel is made up of CCEs. Sorry, the PDCCH, not the PUCCH, the PDCCH, i.e. the downlink channel is made up of CCEs. And that's where you're getting the implicit signalling from.
So one channel, one downlink channel, one control channel has multiple CCEs in it.
Yes. Yeah, it can be one, but it can be multiple. Well, again, when we get to the background in the patent, that will make more sense, but it could be on one CCE or it could be on several CCEs. The other important points in the language of the
What's
claim.
on what? Sorry, I thought a CCE was on a control channel. Now you're saying a control channel is on a CCE.
Well, control channels are made up of CCEs, or the downlink control channel is made up of CCEs, or one CCE. Okay. Some number of CCEs. The other important points about the language to note is that the word here used is associated. So it doesn't refer to mapping or one-to-one mapping. And those are points that those are words, mapping and one-to-one mapping. Mutual mapping is also used, that are in the description. This says associated. And we say, obviously, that's wider. The other thing that it's important to note is that there's no reference to CCE number or CCE index. So it just says the CCE is associated. So it's a general reference to CCE rather than a specific reference to CCE index or CCE number. So we say this is wide, the language. So then we come to the description. And I'm afraid we now need to go back to patent, and we're going to look at some paragraphs that we haven't looked at before, probably some we have already looked at. And I'm doing this from the 549 patent because, as discussed previously, the judge says it doesn't matter, and it's probably easiest to just have the marking up on one. And so that's in the supplemental bundle, tab 1, page 3. And what we see in paragraph 3 is the point that we were just discussing, which is in the middle of paragraph 3, you can see that each L1, L2 CCH occupies one or a plurality of CCEs. And the base station allocates an L1, L2 CCH from among a plurality, etc., in accordance with the number of CCEs necessary for carrying control information. Just so we understand, this is now at this point talking about the downlink channel. So this is where it's going to get the information implicitly to decide which resource to use on the uplink channel. So the downlink channel, although it's called the L1, L2 channel, that's the downlink channel. Now at paragraph 4, there's a reference to the fact that in order to use downlink communication resources efficiently, mutually mapping between CCEs and putches has been investigated. And just noting here that this talks about mutually mapping as distinct from association, which obviously is the word in the claim. And then turning over, the next paragraph we need to look at is paragraph 11, which of course we're all happily familiar with, but we haven't yet concentrated on the bottom bit of column 3, which starts talking about putch numbers and CCE numbers. And so you can see that starting from around line 53, it says here it is assumed that a CCE number and a putch number defined by a ZC sequence signature shift value and water sequence number are mapped on a one-to-one basis. That's to say it's assumed that CCE1 and putch 1, CCE2 and putch 2, and CCE3 and putch 3 and so on are mutually mapped, same applying subsequently. So here...
When it says mutually, does it mean respectively?
Well, I think it's just another way of saying on a one-to-one basis. Not sure what my...
Well, when it says, so CCE1 is mapped to putch 1, CCE2 is mapped to putch 2, CCE3
Yes.
is mapped to putch 3.
Yes, exactly.
So hence, I was wondering if what it meant was respectively.
I'm not sure what my lord means, but yes, yes, perhaps.
Because the word mutually doesn't really seem to fit. But if you understand it as meaning respectively, it makes sense, at least to me.
Yes, I was thinking of it in my own mind as just being repetitious of one-to-one, but...
Yeah, fine. Thank you.
So these CCEs,
Yeah,
these numbers of CCEs are not, a CCE isn't just for one phone, because the phones must get different CCEs.
yes, yes. But the CC... Well, you found the CCE that you need by blind decoding. Some of us remember that from the previous appeal.
Okay.
And I mean, that is mentioned in the judgment in passing. I think it's, again, it's 173 of the judgment, if I recall correctly. Let me just check that.
So there's an L1, L2 control channel specific to a particular phone.
No, my understanding is L1, L2 is, I'm assuming it's just layer 1, layer 2, so it's a downlink control channel. It's another word for downlink control channel.
Yes, but the way, I guess that's what L1, L2 meant
Yes.
too as well. But the way it's described as being on one or more CCE made it to me sound like an L1, L2 control channel was talking about a specific control channel between the base station and a particular mobile phone. just in the same way that the PUCCH is, I think, a specific control channel between one mobile phone and the. It's one of the troubles with the word channel in this context is sometimes what you mean is a channel which is used
Generally. Yes.
by multiple pairs of communications, and sometimes the channel means something that's only one thing. And I'm just trying to understand what the control channel on the downlink side of this, in this discussion, whether it's one that's a channel which every phone looks at, or it's a channel that's talking about the communication of one phone.
My understanding is it's the latter.
One phone.
Yes, I mean, we're going to come on to some further bits of the description, and my learned junior points out correctly that there is a distinction in the description. In some places it talks about L1, L2 channel generally, and in some places it talks about specifically numbered L1, L2 channels. And so, I mean, I'm going to come to this shortly,
Okay.
but for example, in paragraph 23. So certainly there it's talking about one for a specific phone.
Thank you.
So yes, in fact, I think I'm going to come to that now actually, which is so what we've been looking at so far obviously is the background art, and then we come on to the disclosure of the invention, and under the heading embodiment 1, so we're obviously on the specific embodiments here. If we look at paragraph 23, it explains that in the following description it has been assumed that L1, L2 channel number 1 occupies CCE number 1, channel number 2 occupies CCE number 2, channel 3 occupies CCE 3, 4 occupies 4, 5 occupies 5, 5, this is the important bit, occupies CCE 6, 7, 6 and 7, and 6 occupies 8 through 11. So this is showing you that you can have different numbers of CCEs on the channel. Do my lords see that bit? Mm-hmm. So channel number 5 is occupying 2 CCEs, 6 and 7, and channel number 6 is occupying 4 CCEs, 8, 9, 10 and 11.
So these channels, L1, L2, CCH number 1, for example, that's a channel that's only the communication between a base station and one phone.
Yes.
That's what that means.
Yes. And they can have different numbers of CCEs.
Doesn't look difficult to signal the channel index that way.
Sorry, I didn't catch that.
Well, I thought we'd spent some time this morning and yesterday on the difficulty of signalling the channel index, but if it's done that like that, it's not difficult at all, is it?
Well, it requires overhead, because you've got to tell that, because the UE, as we saw in the evidence yesterday, doesn't know which channel it's dealing with unless it's told which channel it's dealing with.
Well, it blind decodes the CCE and it knows both the CCE number and the channel number by doing that, isn't it?
No, I don't think it knows the channel number unless there's some additional piece of information, because it doesn't know what the channels are that all the other mobile phones have been allocated. So it knows it's got a channel, but it doesn't know where that is in the numbering system.
Right.
So I think that was the point that was covered by Mr. Edwards in his evidence. You are blind as the mobile phone. You know this channel is for you, but you've got no idea whether it's channel 54 or channel 2, unless you're told that by some explicit signalling.
Okay. I don't understand how that fits with what you've shown us here, but anyway.
Well, I think
we can come back to it.
Well,
let's not waste time on it now.
Yeah, I mean, this isn't purporting to tell you what the mobile phone knows. It's just telling you that this particular channel is made up of a certain number of CCEs. So then we get paragraph 24, and what that says is obviously that in the following description it's assumed that a CCE number and a push number defined by a ZC sequence, cyclic shift value, and Walsh sequence number are mapped on a one-to-one basis, and then we've got the one-to-one mapping again, similar to what we've already seen, mutually mapped in relation to paragraph 11. So mapped on a one-to-one basis, that obviously has a particular meaning there. And then paragraph 27 is the next one that it's helpful to go to, and that talks about control channel allocation section allocates an L1, L2 CCH from among a plurality of L1, L2 CCHs for each mobile station in accordance with the number of CCs necessary for carrying control information. And that's explained lower down, starting at line 40. For example, when the number of CCs necessary for carrying control information to mobile station 1 is 1, and L1, L2 CCH number 1 has consequently been allocated to mobile station 1, control information generation section, output CCE number 1 to mapping section, etc. And more interestingly, the next sentence, when the number of CCs necessary for carrying control information to mobile station 1 is 4, and L1, L2 CCH number 6 has consequently been allocated to mobile station number 1, then you get the outputs of CCE numbers 8 through 11 to the mapping section. So that's just, again, going back over the fact that sometimes the channels have different numbers of CCEs. And then at paragraph 49, you've got another reference to mapping, and starting around line 19 it says determination section also determines a putch number to be used for transmission of an ACNAC signal from that mobile station from a CCE number corresponding to a subcarrier, etc. And then there's the example. Since control information is mapped on a subcarrier corresponding to CCE 1, number 1, determination section 208, to which above L1, L2 channel number 1 has been allocated, determines putch number 1 corresponding to CCE 1 to be a putch for use by that mobile. And then the example carries on. And the important point in these paragraphs that we've been looking at, paragraph 23, 27, 49, is that there is a link between the channel number and the putch via the CCE.
Well, it's the lowest CCE. If you get multiple CCEs, it's the lowest number.
Well, in that specific example, yes, that's correct. And just to complete this, we need to look at paragraph 56, where you've again got a reference to mapping the sequences, or sorry, mapping the numbers on a one-to-one basis. And that's a reference to figure 10. And obviously in figure 10, and indeed in the other figures, where you've got the code multiplexing structures that we've been discussing, you've got a one-to-one mapping between the CCE and the putch, which is why on the figures you've got CCE written in the square. So we don't contest the fact that in those embodiments, in the figures, you've always got a one-to-one mapping. So we say the upshot of this description is that there is clearly a link, some kind of link, between the channel number and the putch via the CCEs. And since it is well established that it's not legitimate to write limitations into the claim corresponding to the details of the specific embodiments, particularly where the language used in the claims is different, and that's established by Nokia, which I don't think I need to turn up for this purpose. The fact that in the specific embodiments there is some description of one-to-one mapping between CCE number and push number doesn't mean that when you come to the claim, which doesn't use the word one-to-one mapping or mutually mapping, but just uses the word associated, that the only thing covered by the claim is a link to the CCE number or the index of CCEs. And indeed, of course, as I've already mentioned in relation to the claim, there is no reference to CCE number. So we say that there's nothing in the claims or in the description which is sufficient to make and the particular parts that might be helpful to have in front of us again that we were looking at earlier, which was CCE associated with a push. Is on core, well, where I'm looking at it's in core 107. So we're trying to understand what the CCE is associated with the physical uplink control channel means, and we say it is not limited to a CCE number being mapped on a one-to-one basis with a push number, a channel number, and that in fact other types of linking are sufficiently covered, and so that would include a link between the control channel index and the push. So,
What does the word determinative do? At the moment I'm looking at the word determinative, which feels like a one-to-one word that effectively requires a one-to-one correspondence between something and something else.
well, I think in my submission, what's the one-to-one correspondence there is between the push and the cyclic shift value.
Yes.
But it's not between the CCE and the cyclic shift value.
Right.
Because the CCE is not determinative of the push. The CCE is just associated with the push.
I don't understand how that works. So you're saying that the CCE doesn't have to be determinative of the push, but the push does have to be determinative of the cyclic shift value.
Yes, I mean a push is going to be on a particular cyclic shift value.
Yes, exactly. I mean,
And
as far as I can see, the push and the cyclic shift value are not really different things. They're
No,
just the same
fine.
thing.
Exactly, but the CCE is, and the CCE, which is the thing we're looking at, what's the relationship we're asking ourselves between the CCE and the push / cyclic shift value? And the relationship is an association. It is not determinative, it is not mutually mapped, or it is not mapped on a one-to-one basis.
Well, what I'm putting to you is another way of reading it is that this is saying that the CCE is determinative of the cyclic shift value. Now, how it's determinative, I don't know, but why is that not a legitimate reading of this?
Well, because with respect, my Lord has just skipped over and effectively deleted the word is associated with a physical uplink control channel.
Well,
and so
you say, why isn't reading the phrase as a whole, the CCE is associated with the push and the push is determinative of the cyclic shift value, mean that the result is that the CCE is determinative of the cyclic shift value? I don't understand how else it makes sense.
well, because the question is, how does my push know what cyclic shift value to use? It's got to come from something on the downlink.
Well, how does my phone know what cyclic shift value to use?
Fine. How does my phone know what cyclic shift value to use?
Yes, and something has to be determinative of it, and the answer here is the CCE.
Well, it's coming from the CCE, but the CCE isn't determinative of it.
Right.
Because,
what is determinative of it then?
Well, the point about this claim is the patentee, having explained in the description that you can have one-to-one mapping, and that in some cases your CCE number will go on to tell you what your push number is, doesn't say that in the claim. They say something wider, because they're keeping their options open, because there are obviously various possibilities, as we know from the COBE agreement. You can have index of CCEs or CCE number, you can have index of the control channel, you can have index of the control channel candidates. And so our submission is that just because in some of the specific embodiments there is a mutual mapping between the CCE and the push, when you come to the claim, it's clear that the patentee is making it of that integer of wider scope.
Well, you're plainly correct that the language of the claim is different to that in the specific embodiments. Moreover, I see the force of the argument that the word associated appears to be less precise and in that sense broader. But one still has to construe the language of the integer as a whole, and I haven't quite grasped yet what your answer is to my Lord's question about what is determinative of the cyclic shift value, because you've accepted that the push is determinative of the cyclic shift value. And my Lord's question is, well, why does that not effectively mean that the CCE is determinative of the cyclic shift value?
Because the push is the uplink control channel, and the thing that has to be determinative of which cyclic shift value the uplink control channel is going to take is something in the downlink. And so it can't be the uplink which is determinative of the cyclic shift value. It's got to be something, that the whole point about implicit signalling is it's something that's coming on the downlink. And so on the downlink, we know that we have downlink control channels which are made up of CCEs. And so my submission is this language is deliberately vague because it is not saying it's the CCE number even, it's just saying the CCE, and it is not saying the CCE is determinative of the push or is mutually mapped to the push or is mapped on a one-to-one basis. It is using much, much looser language.
Yes. Well, I understand some of what you're saying, but I still don't understand what I'm not understanding, Ms. Lane, is that the one thing this says is CCE.
Yes. Agreed.
And it doesn't say something other than CCE. But your argument on construction is that the thing which you say this covers is something else that's not the CCE, is determinative of the can be determinative of the cyclic shift. And that's the bit I don't understand.
Yes, so the L1, L2 channel, or the control channel, which we know is made up of CCEs,
yes,
can be the determinative thing.
So
this
you
covers...
submit, but the point is the claim doesn't say control channel, it says CCE.
It does, and I fear I'm repeating myself, but it doesn't say CCE number,
No.
and it doesn't say determinative, the CCE number is determinative, or the CCE number tells you which channel to use, or it's mutually mapped onto the push. It just says associated. So the patentee was using deliberately wide language, which doesn't reflect the specific embodiments in any shape or form.
Can I put one reason why it might not have said number? Because in fact, depending on the situation, you don't always use the number of the CCE in the embodiments. You sometimes use the lowest number. So you don't always want to take a CCE number and turn it into a cyclic shift, as you showed us. Sometimes what you do is you have multiple CCE numbers and you only choose one of them to be the one that determines what the cyclic shift is. So that might it be a reason why the reader might think that the claim doesn't simply say the CCE number is determinative of cyclic shift, because in fact, in some of the embodiments, it's more complicated than that.
Well, that is possible, but then you'd expect it to say the lowest CCE number is associated.
Well, maybe it would be the highest. I mean, why does it have to be like that?
Well, the examples in the specific embodiments relate to the lowest CCE number.
Yes.
And it doesn't say CCE number, and again, it says associated.
Is there anything else about the CCE that could be used to determine the cyclic shift value other than its number?
Well, as I said, the point about the CCEs is they make up the control channel.
Sure.
And so we say another, as it were, property of the CCEs is the fact that they form a control channel. And so in that sense, the control channel is associated with the CCEs or is related to the CCEs. And so that is another property of the CCE, the control channel that they form part of, that could be used to make the link, which is our construction, that it covers the control channel number. So just going to the judgment now and how the judge deals with this. So back in the core bundle at page 116. And he just explains at 261 the opposing arguments, and then at 262 he addresses the relevant parts of the specification. We say that he hasn't dealt with paragraphs 3 and 4. That's not a huge point, but they are obviously the paragraphs, or certainly paragraph 3 is a paragraph that explains that the downlink channels are made up of CCEs, so that is part of our case. And although he refers to the numbering of the downlink control channels at paragraph 23, he doesn't talk about the fact that in that paragraph there is a link between the downlink control channel, the CCE number, the downlink control channel number, the CCE number, and the push number. He then obviously takes into account the fact that the specific embodiments can't be pressed too far. But we say that the thing that the judge misses in this paragraph is that the specific embodiments that we've looked through talk about one-to-one mapping and mutually mapping, and the fact that the specific embodiments talk about that more specific type of association is important when it's once you start looking at the claim language. We also say that what the judge says about Mr. Edwards' evidence at the end of the paragraph is not quite right. And since this is a point that Optis also rely on in their skeleton argument, I'd just like to turn up that evidence. So we need to go back to the supplemental bundle for that. So supplemental bundle tab 9, page 160. Is one reference that Optis particularly rely on. And perhaps I could just ask my lords to read paragraph 193. This is our experts' evidence in chief.
We'll do that.
So the reason why this evidence doesn't help Optis is because it's based on Mr. Edwards' erroneous understanding of what the CGK was. So he says he's talking about what the skilled person would understand, in particular in paragraph 11 of the spec, based on the agreement reached in round 1. But as he says 5 lines from the bottom of the paragraph, in fact, we can start a bit higher up, i.e. the idea that the mobile would be able to determine the uplink which resources it was to use to send uplink signals based on the CCEs allocated to it. So his understanding of paragraph 11 is based on his found to be erroneous understanding of the COBE agreement, that it was based on CCEs, not the control channel index. So that doesn't take Optis anywhere. And essentially the same points, the other thing, of course, is he's not looking at the claim language there. And similar points apply when you come to the other bit of Mr. Edwards' evidence, which Optis relies upon, which is in Supplemental Bundles tab 29, page 364. And this is at the bottom of 523, line 24. There's some cross-examination, I think, on this particular paragraph. And my learned friend says, line 4 onwards on the top of 524, the only way the patent describes the Newey determining its put resources by looking at the CCE number. And then he says, yes, I believe that's correct. And then there's some more discussion about that. And I mean, the point here is he's just really being taken to the specific embodiments. So this is nothing more than the point that we already know and understand, which is that the specific embodiments tell you to do it in this particular way, but that doesn't deal with the language of the claim. And of course, as I've already said, his understanding of the CGK was different, so he thought it was to do with CCE numbers anyway.
Sorry, Miss Lane. I'm looking at the what this is about is the judgment paragraph 262.
Yep.
And a sentence in which the judge says that it clearly calls out mapping CCE numbers to push allocations, and that is how Mr. Edwards understood it.
Yep.
That does seem to be how Mr. Edwards understood it.
Yes.
But I thought you were saying he was wrong. The judge was wrong to say that. I thought we were having this. Well, I was listening to you because you told me this was wrong and you were going to show me why, but it looks like it's right.
No, sorry. Perhaps I put my case too high. What I'm saying is that this evidence does nothing more than, well, 2 things. First of all, it's based on his erroneous understanding of the CGK, so it has to be regarded with suspicion. We've seen that it's based on the erroneous understanding of the CGK. But in any event, all it does is says that in the specific embodiments, that's how it's done. So it doesn't take us anywhere. Perhaps that's how I should have put it.
Okay.
All right, but the second finding after the semicolon, he also accepted the only way the patents taught that the mobile could determine its push resource pools by looking at its CCE number.
Yes.
That again appears to be correct.
Yes.
As a recitation of the witness's evidence.
Yes.
Yeah.
Yes.
So
Sorry,
so
I
your
definitely
submission
put it
on
too
both.
high.
Your submission on both points is yes, that's what the witness said, but it doesn't help. Is your submission?
Yes. Yes. Sorry, my notes said not quite right. I think I said wrong. And it probably shouldn't even have said not quite right. But it's not help. It doesn't help. That's the point. And then, of course, we've got paragraph 263, which is the COBE agreement. And I've already explained why we say the COBE agreement doesn't mean what the judge says it means. It's ambiguous, and so that, therefore, doesn't help in construing the patent. And then we've got paragraphs 265 to 267, and in my submission here, the judge has not really taken into account our point about the meaning of associated, because although he says that Apple submits that using the downlink control channel number falls within the language of the claim because there will necessarily be an association. He then says that's incorrect. The reason he says it's incorrect is based on these particular cross-examination documents. And what essentially he's saying is, well, look, in A, 8 is mapped to 8, but in B, 3 is mapped to 8, and in C, 1 is mapped to 8. So when he says what one can see from this is that there's no necessary mapping, the same CCE can be in different downlink control channels. In my submission, he is missing our point, which is that the type of mapping he's talking about there is one-to-one mapping, whereas, and he's saying there isn't one-to-one mapping, and we are saying, well, the whole point of our submission on the claim language is it says nothing about one-to-one mapping, it just says association. And there is an association, but there isn't one-to-one mapping.
Hang on. If you take the sentence 266, first sentence, if you swap the word mapping, I take your point, Ms. Lane, that it says mapping, and your point is that the word in the claim is association. But if you change that word mapping to association, isn't it still right? There is no necessary association from a CCE to a downlink control channel number.
Well,
that's what that shows, isn't it? It doesn't depend on the specific meaning of the word mapping. It would still be true if it said no necessary association. That is right, isn't it?
Well,
if it's not, tell me so, please.
There's no necessary association from a CCE number to a downlink control channel number, but of course there's two aspects to our submissions on the wording of the claim. One is that it uses the word association, and the other is that it doesn't use the word number, it just uses CCE. And for that reason we say CCE is more general terminology. The skilled person knows that control channels are made up of CCEs, and so to that extent there is an association between a control channel, the CCE, and then the push. And that link between control channel number, CCE number and push number is the one that you see described in some of the paragraphs where the number of the control channel is related to the numbers of the CCEs and then ultimately related to the push number.
Can I just ask a question? And this is going to sound like I'm caricaturing your argument, and I'm not intending to do that. I'm just trying to understand the points that you've just made, because it sounds like the effect of your submission is that when it says the CCE is associated with a push, etc., etc., the effect of your submission is that we read that as meaning the control channel is associated with a push, etc.
Well, the effect of my submission is that CCE doesn't mean CCE number, so it means generally the CCE, and that since the skilled person knows that control channels are made up of CCEs, the understanding they would take away from this is that the CCE and the control channel is associated with the push.
So that sounds like the answer to my question is yes, the effect of your submission is that it means the control channel is associated with the push.
Yes, because the CCE is, and because it doesn't say CCE number.
Okay.
And so it covers both of those things. By using that loose word, CCE, and the loose word associated, what falls within that is not just the CCE number, but also the control channel number. So I think I've reached the end of what I wanted to say about the judgment. I can see notes floating around here, so I'm just going to check whether I need to say anything. Not at the moment, apparently, so that's good. So I'm going to move on to obviousness now, unless anyone has any. This is the final topic everyone will be relieved to hear. So when we get to obviousness, we obviously have to work on two assumptions, or our case depends on two assumptions.
Yes, just before you get into the detail, can you help us on this?
Yes.
And I'm not trying to set up some kind of procedural objection, I'm just trying to understand
Yes.
whether or not I've missed something.
Yeah.
But there is a suggestion advanced by Optis in their skeleton that although you do have a ground of appeal about obviousness, you don't say anything about it in the skeleton. And when I read that, I went back to your skeleton and tried to find it, and I couldn't find it. So I was thinking that Optis were right about that, but maybe both they and I have missed it.
So I think I can clear that up perhaps by looking at the grounds, which I believe are in tab 2 of the core bundle. And we've got two grounds under the heading obviousness over Nokia, 14 and 15. And the point is that we're not relying on I think I'm right in saying we're not relying on 14, but we are relying on 15.
Well, that's helpful, but it's not quite the question I was
Oh,
asking.
sorry.
Because it wasn't disputed that you had a relevant ground of
Yes,
appeal.
we've dropped some ground.
And that's always helpful to know,
Yes,
thank you.
yes.
What I was asking for clarification on
Yes, it
was
relates to my skeleton.
where it's dealt with in the skeleton.
Yes. So, it's dealt with core 65 under the heading obviousness of EPA 10. Oh, sorry, I'm looking at the wrong skeleton. That's a bit. That's not very useful, is it? Well, it's only dealt with in paragraph 99 because we say it's so straightforward once you have construed Toby in the correct way and construed the claims of EPA 10 in the correct way. So what we say is simply, if you've got a broad construction of the claims and therefore more than one option falls within the claims, then Nokia renders that feature obvious because there's only one possible interpretation of the Kobe agreement which might fall outside the claims. That's the control channel candidate. That was rejected as unattractive, but the other two, which are CCE index and control channel index, would be obvious.
I'm not sure I quite follow the logic, and I appreciate you haven't really started your submissions on
Yes.
this, and you will explain it, I'm sure, in due course. But
Yes.
at the moment, I'm struggling with the idea that even if Kobe is ambiguous, somehow it's ipso facto obvious to pursue one of the possible interpretations. Doesn't necessarily follow, does it?
Well, it doesn't necessarily follow, but obviously we know from things like Panasonic that that there are these two potential interpretations. One is the control channel index, one is the CCE index, and we say that the control channel index is one possibility within the scope of the patent, and that using the control channel index is obvious. And the reason we say that is not least because it's agreed that this type of implicit signalling is technically possible. And obviously, Optis is saying that that's what everyone was talking about. I mean, they say that that's the meaning of the Kobe agreement.
Yeah, that's what's been dawning on me. Doesn't I mean, obviously put your case as you and your team feel you should, but as I understand now I've grasped this. I think the point you're making here is this it? That on your case, you say the claim should have a broad construction.
Yes.
And therefore should cover control channel index.
Yes.
As a way of signalling.
Yes.
What the cyclic shift should be.
Yeah.
Never mind whether the Kobe agreement was ambiguous, even as construed, which you don't agree with, construed this way, but even as construed as your opponents would say and the judge held, that's you say that it would be obvious to do it that way.
Yes, exactly.
I'm not sure what this. That doesn't matter really, but that's what you're saying.
Yes, that's it.
But as my lord said, it's not just because, even if it is what the Kobe agreement means. See earlier discussion about how easy or difficult it might be to do that, or whether the skilled person would think of ways in which it was possible. Don't those issues all then come into the fore if one is asking the question whether it was obvious to implement something in which you did use the control channel index as the means of signalling the cyclic shift?
Well, I mean, there are various points on this. First of all, given that Optis is saying that using the control channel index is CGK, that they're in some difficulties if they're then going to turn around and say, oh, it was impossible. How can it be CGK in that case? So we're both in a squeeze here, essentially. So the other point that is important, well, there's two other points that are important. It's accepted that it is technically possible to do it because that's what Optis themselves say. It's technically possible to use the control channel index. They say that in support of their arguments on Kobe. And of course, Panasonic points to that as being one of the ways of doing it. And so we say that that's sufficient evidence to show that it's obvious.
Okay.
I mean, I was just going to quickly go to the judgment first of all, so that my lords can see that the judge didn't deal with this point. And then I'll just go back over it. It won't take very long because I've sort of already done it, the points that we rely on. So at paragraph 407 of the judgment, which is on core page 142, what the judge is dealing with here, you can see on the previous page, is steps from Nokia to the patents. And here he's addressing what's required by the A10 patent. And obviously here he's talking about the downlink control channel index. Then he deals with the fact that Mr. Edwards proposed use of CCE numbers. So, and he rejects that as being obvious, but obviously he's dealing with a different case there. So he doesn't deal with the case that we say now arises on appeal. So the way the case...
Sorry, the way you phrase that suggests, perhaps completely unintentionally, that the case wasn't put that way below.
Well, I can't, to be honest, at this moment remember how it was put below, but the point was that in the judgment...
I mean, if the case wasn't put below, I say if, then that would explain why the judge didn't deal with it.
I mean, I'm sorry, my lord, I have to check. I'm not criticising the judge for not dealing with it. I'm just saying he didn't deal with it, so it's not in the judgment, and so that we need...
All right, I do apologise if I said a hair running unnecessarily, but it was occasioned by your phraseology, because you've pointed out, you say the judge doesn't deal with this, and there seemed to be a flavour of that's because it's a new point, but then why is the judge wrong for not dealing with the point that wasn't put?
I wasn't trying to criticise the judge at this point, my lord. I was just simply explaining that I can't point you to paragraphs of the judgment where the judge deals with this point, because there aren't any.
But if it's a new case, then you need permission to run the new case on appeal.
Well, my lord, that's not being suggested by Optis, and it's addressed in our notice and obviously in our skeleton argument, and so we can check, no doubt, back in the skeleton arguments and all submissions exactly what happened at trial. But as my lord has appreciated, there were an awful lot of points at trial, and I'm afraid I can't remember off the top of my head whether this one precisely was run. Leaving that aside for the moment,
it's fair comment that Optis might be expected to know.
Well, one would think that if the point were being taken, you can't run this, it's too late, you didn't run it at trial, that would have appeared in Optis's skeleton argument.
Yeah.
Just going to how the case works, it starts obviously with Nokia, and we've already looked at that, but just to remind my lords that does refer to the Kobe agreement. Perhaps we better turn it up because I'm not sure we've looked at that before. So that's in supplemental bundle, tab 5, page 86. And under the heading 1 introduction, just before the last paragraph under that heading, it says in the penultimate paragraph, it was decided in the last round 1 meeting number 49 held in Kobe that for non-persistent scheduling, the ACNAC resources linked to the index of the control channel used for downlink scheduling. So that's basically the wording of the Kobe agreement. And we say that one possible interpretation of the Kobe agreement is that it refers to implicit signalling via the control channel index. As discussed, that's actually
So am I understanding correctly that that's why this is not a novelty case? Because you accept that even on your reading of Kobe, it's not that it unambiguously discloses what's in the claim. You say that is one of the possible readings of it.
Yes, my lord. And
that's why it's an obviousness case.
Yes.
All right, but I'm still struggling with the idea that even if you're right about the interpretation of Kobe, obviousness, as it were, follows as a matter of course.
Well, if we go to Optis's skeleton for a moment, at paragraph 57, for page 60. Essentially, this is evidence that Optis are relying on in order to say, in relation to the point about CGK and construction of Kobe. But in my submission, it supports our case that it would be obvious because we have here set out the evidence that Mr. Edwards agreed that it would be technically possible to index the control channels themselves by adding extra signals. And further on down that paragraph, Mr. Bradford explained it would not be clear to the skilled person how the control channel index, but his view was that the skilled person would assume that a logical ordering would be made clear in the future, and it was not put, and he did not say that it would be thought it could not be done at all.
So what's the relevance of that evidence to your case? Because that's evidence that shows that it's technically possible.
Yes.
That which is technically possible is not ipso facto obvious.
But in a situation where it's one possible interpretation of the agreement, so one possibility is use the control channel index, and so therefore you know that that's a possibility, and it's technically possible, we say that adds up to obviousness. I mean, this.
But why? I just don't know. You seem to be assuming that this is 1 + 1 = 2, but why?
Well, because it's not as though the thought isn't going to occur to anyone because it's one possible interpretation of the COBE agreement, and the experts agree it can be done. Therefore, we say it is obvious.
Right.
And in addition to that, we also rely on obviously what's in the Panasonic document. And Panasonic, just to remind my lords, is that supplemental bundles have 18, and it has pros and cons of the two different options set out in section 2 on page 276. So ACNAC resource is linked and to the index, or it's linked to to the index of the L1, L2 control channel, or it's linked to the index of the control channel element. And there are pros and cons of each. And that supports the fact that it's something that people are talking about and not suggesting it can't be done, and therefore it is obvious.
All right, but this brings us back to the discussion we had before about whether this is or is not a new case, because the way you're putting it now would seem to me to be something that ought to have been put to Optis's expert, because the cross-examination would go roughly as follows. Please assume one possible interpretation of the COBE agreement is, as we say, you accept it's technically possible to do it, don't you? Yes. Therefore, it's obvious, isn't it? On that hypothesis. And the witness either says yes, or he says no and gives reasons. But you haven't relied upon any such evidence.
My lord, I think I need to have that as homework, if that's acceptable, in the sense that I don't know, I would like to be able to tell the court whether that evidence exists or not.
So, because it would seem that either the point was put to the witness and not pursued in submissions before the judge, which is why you didn't deal with it, or it wasn't put to the witness, in which case, why is it open to you now?
Yes, my lord, again, I'm afraid that wasn't a point that I understood Optis to be taking, so I'm afraid we haven't addressed it, or I haven't prepared to address it. So, can I beg the court's indulgence to come back with, I think I've got two bits of homework now. There was the bit from earlier in relation to construction of the COBE agreement, and there's this other bit now which I will track down. And I am at the end of my submissions now, subject to any points that my lords may have. But I think if it's acceptable, I'll bring my completed homework back after the short adjournment.
Yes,
let me just check whether those around me want me to make any other points at this stage. And do my lords have any further questions? No. I'm grateful for my lord's patience.
Thank you very much, Ms. Lane. Mr. Hissif.
My lords, if I can follow essentially the same structure as my own friend, after a short introduction, I'll deal with the technical background and perhaps spend a little bit more time on some of the more complex issues that my own friend only touched on briefly yesterday, and then deal with the points of construction and infringement, and then knocking. Now, as my lords have seen, the case is about the way that 4G LTE phones transmit two types of control signalling in the uplink. And they do that on the push, which is the physical uplink control channel, which is a shared channel that has multiple phones transmitting at the same time. And that process is called multiplexing. The control signalling in question is the HARC feedback and the CQI feedback, and my lords have heard that. Each of that signalling is from the UE and is related to the downlink signalling coming from the base station. So just in brief, the HARC signalling, when the base station sends a packet of data to the UE on the downlink, after each packet, the UE attempts to decode it, and if it can do so without errors, it sends back a 1-bit message, the ACK message, which means, I got it, keep going. And if it can't, it sends the negative acknowledgement, I didn't get it, try again, please. And that process is a way of obviously improving the error rate of overall transmissions at a slight cost of latency. The CQI information that's also multiplexed on the push is a measurement by the UE of the downlink signal quality, and the base station uses that for multiple reasons. One example of how it uses it, of course, if one UE is saying I've got very poor channel conditions, and another UE is saying I've got absolutely tip-top perfect channel conditions, the base station can use that in deciding who to send data to at that particular instance, and you send it to the one with the best conditions because it's got more chance of getting through. Now, as bandwidth on the control channel, on the push channel, takes away from bandwidth available for user data, it's important to make sure that the control channel is used as efficiently as possible. And the patents provide a way for efficient transmission of this signalling from multiple UEs at the same time. It allows the transmission of ACNACs and CQIs in the same resource, block, and they're separated by two types of codes: the Kazakh Z-G codes and the Walsh codes. But because it's possible for interference to take place between the UEs, a key part of the patent is the allocation of the particular code combinations to the UEs and how they're done, because squeezing too many UEs into a particular resource block can end up with interference that will result in the signals from all the UEs not getting through. And what the invention does is it balances those two factors: the throughput of push and getting as much control data through as possible, with avoiding interference. And that's the first aspect of the invention of the patents. The second one is the one we've been talking about this morning, which is the implicit signalling, and that allows, and the 810 patent claims, a scheme for signalling whereby rather than the base station saying to each UE, when you acknowledge this packet, please send it on cyclic shift 1, Walsh code 0, the UE determines that from the resource that the base station uses to tell it that it's got data for it. So just to pause there, one of the things my learned friend didn't mention, and maybe my lords have this, is in the downlink there are two channels. There's the downlink control channel, which is called the PDCCH, and then there's the downlink data channel, which is the PDSCH. And when a base station has data for each UE, it sends a message on the PDCCH, which gives the UE the information of where and when it's to find the data on the shared data channel. And it's the part of that resource that's used to send that message that implicitly tells the UE this is the push resource to use in the upland. And that's another way of more efficiently using in this case, the downlink control channel. Now, at trial, Optis ran a large number of points. It alleged obviousness over the TDOC by Panasonic. And just pausing there, that's a different Panasonic TDOC, but my lords may not have, the penny may not have dropped. So although Optis is currently the patentee of this patent, this was originally filed by Panasonic. So when my learned friend was talking about the other Panasonic TDOC that we'll come on to shortly before the priority date, she is talking about a document put in by the inventors of the patent. There was obviousness over Nokia, and both those obviousness cases were dismissed by the judge, and there's no challenge to those conclusions. There was the non-infringement argument, which we've heard of in the appeal, which I'll come back to, based on the issue of the mixed resource block implementation in the UK. There was then the accidental anticipation squeeze, which again we'll come back to, and then various grounds of opposition to the amendments that were made to the claims. So the large number of issues were thrown at the patents, and the judge dismissed them all in his careful and detailed judgment. And although on appeal, the majority of the obviousness findings are not challenged by Apple, ultimately, as we heard just a moment ago, we do end up with a challenge to the finding that the 810 patent wasn't obvious. And for that reason, can I just show you, Lordships, very briefly, the judge's conclusions on the witnesses. So if we go to the judgment, and that's Core Tab 5, and pick it up at paragraph 18. So first of all, the judge deals with Optis' expert, Mr. Bradford, and there were a couple of criticisms made of him by counsel for Apple. The first was lack of experience of Etsy and RAN 1 in paragraph 20, which the judge didn't think there was anything in. We see at the end of the paragraph over the page. And secondly, a criticism was made that he had a distorted view of the test for common general knowledge, and the judge concluded he didn't think Mr. Bradford did this. So neither of those two criticisms found favour with the judge. In contrast, Apple's expert, Mr. Edwards, some of the criticisms made of him the judge did accept. So the first one in 24 was that Mr. Edwards was more familiar with the RF aspects of cellular systems rather than the physical layer and RAN 1. Of course, my lords will have it. This case is about the physical layer. And there was a point the judge deals with in 24 where he said there was nothing in the point about how he'd expressed his expertise. But in 25, the judge did find that a number of aspects of his evidence showed a lack of familiarity and comfort with the physical layer, and he's taken that into account. And he gives the example of him having not thought through the real-world implications of using a mixed resource block. So that was one point that the judge accepted. In 26, the judge noted that Mr. Edwards had previously given evidence before my Lord, Lord Justice Arnold, at first instance, in Phillips and Aces. He'd given evidence that various documents like technical reports and meeting minutes weren't CGK, yet in contrast in this case, when acting for an alleged infringer, he gave the opposite evidence and said that they were common general knowledge, and the judge thought that was significant. And then in 27, another point, a number of areas where Mr. Edwards had raised points in oral evidence the first time, and obviously the judge makes the point that sometimes that happens because counsel asks a question for the first time. But in this case, some of the points Mr. Edwards made were artificial and not very well thought out. And in the light of all that, the judge approached Mr. Edwards' evidence on what was CGK with caution in 30, and a little scepticism about his evidence on the details of what to do with the cited prior art. And of course, one of my learned friend's challenges to the judge's finding on CGK of Kobe, and then finally we get on to obviousness over rate attack. So whilst I accept this isn't a standard straightforward obviousness case, there are aspects of it that come in, and my lords need to know that as part of the background to the action. So now, if with that, those comments, if we can come on to the move on to the technical background, and I'll go a little faster than I planned to because obviously my other friend did deal with some of these points. The first one, if we can, is just to ground ourselves in time of the patent. The priority date is August 2007, and at that stage the LTE system was under development. So we're considering LTE, but we're considering at a time when it was being standardized. So then if we can turn on in the judgment to paragraph 67, we come to the section headed multiple access methods. And my other friend focused on code division multiple access, which is, we agree, the most important multiple access method. But frequency division multiple access that the judge deals with in 69 is the basis for LTE. LTE is fundamentally a frequency division system that has code division applied on top of it. And then when in 71 the judge comes on to talk about codes, and he goes on to look over the page in paragraph 79 about orthogonal codes. And I hope my lords understand how basic code division works. My learned friend gave the example of someone talking different languages and talking French. that's, as all these analogies are, that goes so far. But the important thing about the code to keep in mind is that when the base station receives the signals from the multiple UEs and applies each of the codes to the signal, the magic of the math of the orthogonal codes is that all the other languages disappear to nothing, and all it gets left with is the code of the UE in question. And that's how it's able to have multiple UEs transmitting at the same time, and the base station be able to pick out each of those individual transmissions and decode them properly. Now, if we go on to the impairment point, the judge refers to the various different types of impairment, and an important one to understand for the patents is what's referred to as delay spread. Now, as my lords will be aware, when a phone, which is fundamentally a radio transmitter, transmits its signal to the base station, that signal can't always fly in a dead straight line to the base station. And it inevitably will bounce off buildings, cars, hillsides, everything like that. And those reflections, those signals, when they arrive at the base station, because they're all travelling at a finite speed, at the speed of light, will arrive at a slightly different time. And what that means is all those signal components arrive slightly differently, and they can interfere with each other, and sometimes cancel each other out, sometimes add to each other, but will arrive at a different time. And that's important because it affects particularly the Kazakh codes. Now, we can turn on to 114 of the judgments, which is where LTE was at the priority date. And the judge refers to the requirements being finalised in June 2005, and that's the high-level aims of the system. And in 115, he says the selection of OFDMA for the downlink and SC-FDMA for the uplink were key design choices. Now, just unpacking what those are, he described those earlier. So we go back to 74, back 4 or 5 pages. So OFDMA is orthogonal frequency division multiple access, and that involves multiple carriers. So that's multiple frequency bands, and each individual carrier is a subcarrier, and they're separated by a spacing of 15 kilohertz. And the effect of choosing that spacing in the symbol period means that they are all orthogonal to each other, and so that the UE can transmit multiple different frequencies at the same time, and the base station can receive them. And as my learner friend explained, if we go on back forward again to paragraph 119, you see the resource structure of LTE, which has, one sees that grid there. In the vertical columns are the 12 subcarriers, and horizontally one's got time. And to answer, I think my Lord Justice Arnold got the answer yesterday, but my Lord said, what is a symbol? A symbol period is a period of time on a particular carrier that the transmitter is able to then modulate in a particular way to transmit a piece of information. So every symbol period is an opportunity for the RF carrier to be modulated, and depending on the modulation scheme that's used, that can transmit 1 bit, 2 bit, 4 bits of information. The judge then comes on to talk about HARC and CQI, and we've my Lord are now familiar with what those are in the generality. If we go to 124, we see how it was proposed in LTE at the priority date. So data would be sent by the node B, which is the base station, on the downlink data channel, PDSCH, to the UE, which would attempt to decode it, and then the ACNAC would be sent back either on the push or the push, which is the uplink data channel. And as the judge explains, if the UE was also allocated uplink resources to transmit itself, it would send its ACNACs back on the push. Otherwise, it would be sent on the push. And it's that latter circumstance that the patent deals with. Then, if we go on to 100 and...
Oh, I see. So if the phone is already transmitting data back to the base station, it will have a push, and it can use that.
It
If it's
smuggles.
not, which it might not because it's only receiving data from the base station, then it'll use the push.
Yes, if it's got an allocation already, it smuggles the ACNACs along with that data, and that frees up more of the push for other phones that haven't got data. The judge then refers to, in 128, to the uplink channels, and those, the very high-level structure mirror the downlink in the sense that there's an uplink data channel, as we've discussed, and then the uplink control channel, the push. Now, if we go on to 135, the judge looks at 134 under the headings the LTE standards. The judge sets out how the data on the push was going to be transmitted, what was known about that at the priority date. So if we go to the table in paragraph 138, just over the page, and my learned friend touched on this briefly, we see that the table has a number of formats, and my lords may have understood just from looking at the table what the formats are, but a data format is a way of having signalling that a particular bit can mean one thing in one circumstance and another thing in another. So, for example, format 0 here was going to be the scheduling request. So if the UE transmits in format 0, the base station knows that that particular signal means a scheduling request. If it's transmitting in format 1 and it's told the base station this is format 1, the base station knows that the same bit means something different. So it's a way of having more flexibility. Now, in 140, the judge refers to the reference to reference signals. Now, reference signals and reference are the same thing as effectively pilot signals, and what they're there for is to assist the receiver to demodulate the received data signals. And again, forgive me, my lords, if this is familiar territory, but in nearly all the modulation methods that these radio systems use involve transmitting the information by shifting the phase of the transmitted signal. So BPSK, we see the modulation scheme there, is binary phase shift keying, where the phase is shifted by 180 degrees or not to signal a 0 or a 1. And in order, because when the signal is transmitted from the transmitter to the receiver, as I mentioned a moment ago, it bounces off the environment. Those reflections will shift the phase. So what the reference symbols do is because the receiver knows the phase that they were transmitted with, it can compare the received phase of the reference symbol with the received phase of the data symbol, work out how they were different, and effectively extract the difference between them. So they're a key part of the transmission scheme. And as the judge explained, what had been agreed there would be in a normal slot there will be 3 reference symbols, which leaves then 4 for data, although there could be a different format which might only have 2. But the fundamental structure of the LTE resource block in the time dimension was 7 symbols, 4 data, 3 reference. But as the judge says at the end of 140, there was no indication where they should be positioned. Now, we then go on to pass over.
Is this the uplink or the downlink?
This is the uplink, my lord. This is the push. If we then go to 143, the judge describes how the 2 sets of codes that are relevant for this case are applied. And as he says in 143, the complex value symbol is multiplied by a cyclically shifted length 12 Kazakh sequence and then blockwise spread with an orthogonal sequence. So far, so good. And then in 144, he explains what Kazakh sequences are. And I just wanted to take this a little slower than my friend did yesterday, just to make sure my lords have it. So a Kazakh sequence is a constant amplitude sequence that has the property that it has, the judge says, it has no correlation to a time-delayed version of itself. Now, that may need a little bit of unpacking. The sequence is a sequence of 12 complex numbers. It doesn't matter that they are complex numbers rather than real numbers, but 12 numbers. So it's a sequence with 12 elements to it. And those are to be used in the frequency domain. It's not a coincidence that there are 12 of them, because each of the elements of the Kazakh sequence was going to be modulated onto one of the subcarriers in the resource block, which my lords will remember was 12. And as the judge explains in 146, the properties of the length 12 Kazakh sequence are such that 12 mutually orthogonal sequences can be produced by applying 12 different cyclic shift values. Now, again, forgive me if this is self-evident, but it wasn't to me when I first came to this case, and my learned friend didn't explain it yesterday. A cyclic shift is if my lords imagine a sequence of the 12 elements of the sequence in an order from 1 to 12. A cyclic shift involves rearranging them by shifting them all along by 1 and taking the end one back to the beginning. So if we have a sequence 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, a cyclic shift of one of those is having those numbers in the order 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 1. And a cyclic shift of 6 involves shunting them all along by 6 positions. So that's what we mean in this case, where we talk about a cyclic shift. It's not really rearranging the order of the numbers, because they all stay relative to each other in the same position, but it's, if one imagines them on a band, it's moving them around. And because the magic of the maths of the sequences is that a cyclic shift version of the same sequence is orthogonal to all the other cyclic shifts, by doing that, in one sequence of 12 numbers, you get 12 codes that 12 different UEs can use, and when the base station receives the signal, it can tell them all apart. So that's the first part of the multiplexing process, which is you can then get 12 UEs transmitting at the same time by using the Kazakh code. Subject to the point I'll come back to in a moment about interference. The second aspect of it is the orthogonal codes, and the judge comes to those at paragraph 148. And those are codes similar to the ones he illustrated earlier on in the judgments. And what they did, when those are applied, that means that a UE, even if they're using the same cyclic shift of the same Zadov-Chu sequence, those transmissions can be distinguished from each other. So we go from being able to distinguish between 12 UEs, so if we're using 4 orthogonal sequences, we now have 12 by 4 possible code combinations. And what had been agreed at this stage is that those, for ACNACs, you were going to have both the cyclic shift of the Kazakh sequence and the orthogonal sequence, whereas for CQIs, which was format 3, and we turn over to paragraph 153, they were just going to be multiplexed by the Kazakh sequence. And that's why when we get to it with the patterns and some of the diagrams illustrating the LTE code multiplexing structures, we see the CQE as a stripe. Not because it's using all the Walsh codes, but because it's not using any of them.
So does this mean if you're looking at the uplink at a sort of time, you can say that in the 12 subcarriers, if that's what they're called, 12 different frequency subbands of a piece of uplink for a certain amount of time, you can have 48 different phones in theory.
If they were using both the Kazakh
yes,
sequences
for both.
and
If they're using both the 12er and the other one, the 4er.
in theory, my
In
lord,
theory,
yes.
I understand, and you're going to explain why the theory doesn't work. But in theory, you can get 48.
Yes.
And that's in the same time over 12 frequency subbands. That's the point.
Yes, because the resource block is 7 symbols by 12 carriers, and the UEs can be, 48 UEs can in theory be distinguished because they will use one of 12 Kazakh codes, one of 4 Walsh codes, and that gives 48 code combinations, which can be used,
Which are all distinct from each other.
in theory, all
In
distinguished
theory,
from each other.
if everything's perfect.
Now-
And that's in your 7 slots, 3 of which are a pilot.
Yes, and the reason why the orthogonal codes are length 4 is because there are 4 data symbols, and the way, as my lord may remember, code division multiplexing works is you take a single modulation symbol and you have to spread it with over 4 symbols. You have to use it length 4 length code, so you need the 4 symbols. So there's the reason why the codes are length 4 is because there are 4 data symbols being transmitted. The codes, just for information, the codes that we use to spread the reference symbols were length 3, the same reason. So if we go on to paragraph 164, this is in the section on disputed common general knowledge, but we can take it from here because of the judge's findings. Perhaps my lord could just read 164, and in particular the indented part, which judge explains the issue of interference. A little bit hard a little bit of a dense paragraph, but the bottom line is that a delayed Kazakh sequence with no cyclic shift is identical to a non-delayed Kazakh sequence with a cyclic shift of 1. And that's why the delay spread problem was an issue, because if the sequence suffers from, if the transmission suffers from delay spread because it's bounced around the environment and ends up coming 1 symbol period later than it should do, or a period of time later than it should do, the base station can't tell it apart from a transmission with a single cyclic shift. And we see that in the diagram. So we see the top one is a delayed sequence starting from sequence element 0 through to 11. And underneath it is a sequence that hasn't been delayed, but has been cyclically shifted once, so it starts with 1 and then starts with 0. And you can see that as the receiver sees them in time, they're aligned and it can't tell the difference between them. Now, so far, we've mostly been talking about the uplink. We need to just touch on a couple of points, which I think some of which may have become a bit clearer this morning in the light of my friend's submissions, but I just want to make sure they are. My laws do have it. If we go on to 172, actually, sorry, my laws now. I'm just going to, before we get that, just a bit of point the judge deals with in 157 first. Sorry. So 157, he says the relevant standard also includes a section that relates to the physical downlink control channel, PDCCH, and it describes that the PDCCH carries scheduling assignments and is transmitted on an aggregation of one or several control channel elements, where the control channel elements corresponds to a set of resource elements. So the PDCCH, as I mentioned at the outset, is used to transmit the scheduling assignments, which is the message from the base station saying, I've got some data for you, particularly UE, go here to find it. And that channel was known to be made up of an aggregation of one or several control channel elements, which was known to be a lump of resource elements. Then if we go on to 172, well, I was going a moment ago, the judge deals with the common general knowledge over the PDCCH. And there was a dispute as to the degree of knowledge, and it was common ground that it was common general knowledge that would be aggregation of CCEs on the downlink, because that was in the standard, and that the UEs would find out their individual control channels by blind decoding. Now, again, I think at least my Lord Justice Arnold and Lord Justice Birss understand what this is because of the last case in this sequence. But blind decoding is a process whereby on the PDCCH, so this is the downlink control channel, rather than the UEs knowing where messages for them will come, so being told this is your specific channel all the time, they're required to decode a certain portion of the PDCCH and see whether there is anything for them. And the details of how they do that don't matter, but they look at it all and they may find something for them or they may not. And that process of looking to see whether there's something for them is called blind decoding. And it was known that that process was going to be used. There was then, so that was common ground, that was common general knowledge, but the judge found this at the end of the paragraph, any greater detail was not common general knowledge, consistent with his analysis above. So not very much detail about the PDCCH was known either. And then a few final issues on the technical background. One, obviously, is the judge's interpretation of Kobe, which we'll come on to. Secondly, there had been a dispute at trial as to whether mixed resource blocks, so those are the ones that the patent deals with, were common general knowledge. And the judge found that they weren't in paragraph 186 to 196 of the judgment. Now that may not matter so much for Nokia, but it is part of the overall background. And then finally, just to pick up a few points, very slightly out of sequence, back in paragraph 48 of the judgments, on documents. So in 48, it was common ground that the current specifications would be common general knowledge. But then over to 51, it was also agreed that individual TDocs were not common general knowledge. And that's important when we get on to the arguments on the 810 patent and the Panasonic TDoc that my friend places so much weight on, because that document itself wasn't shown to be common general knowledge. The judge then had some comments about how TDocs had been deployed in the case, and at the end of the paragraph he said, I should say there's a difference between looking at what real people thought a document meant, which is ultimately a matter of law, and looking what they thought could be done with it. And when we come to Kobe, some of the documents that he referred to we'll look at do show what people understood Kobe to mean. So, my lord, I was going to come on to the patents now. Is that a convenient time?
That's a very convenient moment. So 2 o'clock.